Hello everyone, good evening. Good evening everyone. I hope you all can hear me. Please can someone confirm that they can hear me?
Yes, I can hear you. Good
So,
evening,
good
William.
evening. Sorry, I can't hear you. Can anyone hear me?
Hello, good evening.
Hello, I can hear you.
All right.
I can also
I
hear.
would
I can hear
want
you
to
too.
assume that you all can hear me. Good evening and welcome to the JIIPCC Mentorship and Internship program. We are in our week one of the ADR program. Thank you so much for joining us. We're so happy to have you here with us. Welcome to our first class officially. I would like to kindly ask that if it's possible, can we have more mentees just go ahead and reach out to their other colleagues or their other mentees to join in for the class, telling them that we are starting right about now and we'll be getting straight into business. So thank you so much for joining in for the session. We are really happy to have you all here with us. So going straight to business, once again, you are welcome to the Gypsy Mentorship and Internship Program. And I hope that we'll be having an exciting class today. Our first topic for the week is on an overview of ADR, right? We are doing this, or we are bringing this mentorship in partnership with the Settlements House ADR Training Institute. For I think about a year now, we've been partnering with the Settlements House Training Institute to bring the ADR course to our mentees. And I'm sure over the course of the last 1 year, our mentees have gained quite a lot from this program and also been able to get further mentorship from the Settlements House ADR. I want you to be open-minded. We are going to be having quite a very interesting 7 weeks. And I'm sure I can see our mentor, Mr. Niacham, is already here with us on the call. So I'll just go straight into business to try to introduce our mentor, and then we'll take presentation. The format in which this class is going to be taken is that we would have presentation immediately after we introduce our mentor, and then our mentor will give us his lecture, give us a feedback into the presentation, and then feedback into the presentation, and then we'll take questions. And before we go into, we'll take questions, and then we'll call it a day. All right, so our mentor for today is Mr. Nyachan Namwan. I hope you all can see my screen. Yes, Mr. Nyachan Namwan. Mr. Nyachan Namwan is a lawyer and the principal partner of the law firm N. Nyacham. Sorry, please kindly a minute, please. Okay. N. Nyacham and Co., a law firm based in Kaduna, Nigeria, is a certified teacher, trainer, and facilitator. He is a faculty member and executive director of the Settlements House ADR Training Institute, an institute for training, certification, and practice of alternative dispute resolution. He is also a member, as well as faculty member, of the Nigerian Institute of Chartered Arbitrators, a model arbitration certification institute, a model arbitration certification institute in Nigeria. He is certified. He is a certified dispute resolution specialist, an international mediation campus trained mediator, an attorney mediator, a certified mediation advocate, an arbitrator, a certified negotiator, an ADR practitioner, a restorative justice practitioner, and a certified emotional intelligence specialist. He is a certified conflict manager, a certified ADR registry/secretary, a holder of Mediator Academy, United Kingdom Certificate in Commercial Mediation, accredited by the Institute of Chartered Arbitrators UK, a medical law enthusiast, an employment and labor law expert. He is accredited and he is an accredited and trained mediator with Accord and International with Accords International, India, and has completed a course to becoming a Florida Supreme Court certified county mediator in the United States of America. He served as a judge and expert assessor in many international mediation and negotiation competition. He has mentored many students and non-students in the theory and practice of ADR. He has keen interest in the application of ADR in the resolution of medical and negligence disputes, workplace disputes, commercial mediation, faith-based disputes, land disputes, family disputes, amongst others. As a dispute resolution specialist, he has handled several disputes which were amicably settled out of court. He is ever willing and ready to volunteer for and contribute to the development and practice of alternative dispute resolution. He is a facilitator for the Professional Diploma in Education of Institute of Education, Ahmadu Bello University, Zaria, as well as an external facilitator for the Federal Polytechnic, Kaduna. He is married to his wife, and blessed with two children. Thank you so much, Mr. Nyacham, for joining us. We are so happy to have you here with us. You are welcome, sir. So we'll be getting straight into the business of today. Like I said, okay, we also have Miss Natalia Odiba, Odidika. Sorry, ma, for not correctly pronouncing your name. Sorry, ma, we did not prepare your flyer ahead of time. We're so sorry about that. Um, we're so sorry about that. I hope you are able to forgive us, ma'am. Miss Natalia is also one of our mentors on the ADR course. She has been with us for I think two quarters now, and it's really lovely having you around, ma'am. So we'll be getting into the business of today. We'll be having presentation from Group 1 of the ADR from the ADR mentees. So please, if the group presenter for Group 1 is available, can we kindly go ahead and start with the presentation? Can we hear me? Can we all hear me? All right, thank you, Perpetual. So please, do we have the presenter for Group 1 on call? Right, so that we can go ahead and start with the presentation. Do we have anyone from Group 1 that is currently here with us on call?
If Group 1 is not ready, let Group 2 go ahead.
Okay, good evening, Dennis. Can you hear me? Hello, can you hear me?
Go ahead, we can hear you.
Since I'm from Group 1, and since our presenter is not here yet, I might just quickly do the presentation for my group. My name is Esther Chioma, and I'll be representing Group 1 for this presentation. Please, I'm still trying to get my hands around this Zoom thing. I don't know how to share my slides. Dennis, please, can you hear me? Help me with that. I'll just go on with what we prepared for today. I will just use my
Esther, please go ahead.
I'll be speaking on. You've not been hearing me. Can you hear me now?
We can hear you. Go ahead. Maybe you were muted.
Oh, okay. I'll be speaking. I didn't know I was muted. I was trying to look at the slide. Okay, so I was saying that can you still hear me?
Yes, go ahead. We
Okay,
can see your slide as well.
Okay, good. Okay, so I was saying that our group presentation is on the overview of ADR, particularly negotiation and mediation. And our content covers introduction to ADR negotiation, the advantages, the feature, the types, and same goes for mediation, and we'll just conclude. So we all know that ADR is just fully for alternative dispute resolution, which is an extension of the traditional court, a way of quickly dispensing justice. And the ADR provides a sort of more suitable and advantageous approach to conflict resolution, especially when it's not criminal. And this is why the court and other legislative enactments advocates that disputes be resolved through this means, rather than the already congested and traditional court. So what is ADR? ADR is alternative dispute resolution, an alternative means of resolving disputes as opposed to the traditional court, as I've said earlier. And the sole purpose of ADR is to resolve disputes. Now, what are the advantages of ADR over the traditional court? One of them is the fact that it's confidential in nature. So the procedure for ADR is usually the parties involved and perhaps the mediator or the conciliator or just the negotiating parties. It's not like the open court where every person can hear and see what's going on between the parties. It's also cost effective. Not all of them though, but a number of the ADR forms are cost effective. It's flexible, and it can also preserve existing relationship between the parties, especially negotiation. There will be no bad blood between the parties. We don't have anybody going to jail or anything like that. And it also brings about a quick dispensation of justice. I think this is the most important advantage of ADR. The fact that the dispensation of justice can just be quickly done. So we'll be going to the types of ADR, we have negotiation, we have mediation, we have conciliation, there's arbitration, we have mini trial. But our main focus for this presentation will be on negotiation and mediation. So what is negotiation? Negotiation is a process of dialogue and discussion between two or more parties with the aim of reaching a mutually acceptable agreement. It involves a give and take, compromise, and problem-solving situation. It is a form of alternative dispute resolution whereby the disputants communicate with each other directly or indirectly about the issues in disagreement in order to reach a settlement about their differences. What are the features of negotiation? One, we have two or more parties always involved in we have two or more parties. Negotiation always involves multiple parties with differing interests. So we have two persons who are on two opposing sides of the table who are hoping that at the end of the day there'll be a compromise and a shaking of hands between the parties by the end of the day. Now, it's also interdependence. So parties in negotiation are usually interdependent, meaning that they need each other to achieve their goals. So if one party is not willing to negotiate, there will not be any achievement of any goals of achieving the goal of negotiation, which is to reach an agreement. The third one is communication. So effective communication is very important in understanding each other when it comes to negotiation and reaching an agreement. The fourth one is compromise. Most negotiation will require either or both parties to compromise to an extent and find a middle ground so that they can just reach or achieve the goal of negotiation. Now, what are the features of negotiation? We have another continuing feature for negotiation. We have one is goal-oriented. So negotiation has a specific purpose, whether it is to close a deal or resolve a conflict or reach an agreement. Another one, it is voluntary. So you don't force the parties to agree to terms. Is something that first of all they enter voluntarily, and also the resolution they come up with is also something that they come up with voluntarily. Another one is the process. The negotiation process it unfolds over time and also in different stages. So the parties, they will prepare, they will discuss, and then they agree. Those are the stages: the preparation, the discussion, and the agreement, which is when they have reached the goal of the whole process. Now, there are different types of negotiation. We have one, distributive negotiation, which is a win or lose situation. We have integrative. We have integrative negotiation. This type of negotiation seeks to create value and find solution to benefit all the parties involved. It also emphasizes on collaboration, problem solving, and understanding each other's interests. Example of this kind of negotiation is business partnership, where the parties work together to achieve a common goal. And that type of negotiation is principled negotiation. This approach focuses on objective criteria, fairness, and mutual understanding. It separates people from the problem and seek to find solutions on principle rather than from positions. So this form of it's also a form of integrative negotiation. Like in business, you're not looking at can you still hear me? Hello, am I still being
Chioma, are you
heard?
with us?
Yes. Yes. Please. Oh my God.
Hello, Chioma, can you hear us?
Yes, I can hear you. Have you been hearing me since before now? Hello. Hello, can you hear me?
Hello,
Please
Chioma,
go
can you hear
ahead. We
me?
can hear you. Go ahead.
Okay, thank you. I thought I wasn't being heard anymore. So we have multi-party.
Please,
Okay,
can
we have
anyone hear me, or is it just me that is not hearing her?
No, sir, we can hear her, sir. We can hear her.
Okay, so we have team negotiation. This involves multiple people on one or both sides of the negotiation, and it requires internal team alignment and good communication. We have a multi-party negotiation. In this type of negotiation,
Hello, can we all hear me?
Yes, we can hear you. So a multi-party negotiation,
All
3
right.
or more.
I guess Chioma is having a little network issues, so sorry
What?
about that. I hope, or do we have a backup presenter who can step in on Chioma's behalf to complete the presentation?
Okay, sir. I think I can continue from where she stops, sir.
You can, Lawal, you cannot hear me.
Me, I can hear you clearly. I don't know for the other people.
Oh,
For me,
okay.
I can
Sorry
hear you.
about that.
Is there a place you can type that I'm speaking?
Me now, I can hear you clearly. I don't know for others. Sir, please,
Hello,
can you hear?
Esther. Hello, Esther. Can you hear me?
Yes, I can hear you, sir.
I think you should just go on with your presentation. If at some point we can hear you, then we'll draw your attention to it.
Okay,
Just go
thank you very
straight.
much. Thank you very much, sir. All right, so we have the last type of negotiation, which is second to the last. We have informal negotiation. This is just the normal day-to-day negotiation where people decide over lunch and just reach an agreement. Then we have the formal.
Chioma, you are muted. I can see that you are muted. So if you are speaking, you're not longer audible. The sign shows that you're muted. So you might have to unmute and continue.
Am I being heard now?
Yes.
Okay, thank you. Perfect. So I was saying we'll be going straight to types of for going straight to mediation rather. Mediation is a type of ADR, a form of ADR rather, where in which the disputants have an impartial person called a mediator who mediates between the two parties in order to reach an agreement. He does not intervene in the process. He does not he just I think what the mediator does is just provides a platform for the disputing parties to talk to each other. Serves like an impartial umpire, just like the judge. Now there are different types of mediation. We have the facilitative mediation, and in this type, a professional mediator attempts to facilitate negotiation between the parties in conflict rather than making recommendation or imposing a decision. The mediator encourages the disputants to reach their own voluntary solution by exploring each other's deeper interest. We have the court-mandated mediation. This is the one that is mandated by the court. So although mediation is supposed to be a voluntary process, it can also be mandated by the court that is interested in promoting a speedy and cost-effective settlement when the parties and the attorneys are reluctant to engage in mediation. And the odds of settling through the courts, through the traditional court, might take time. So the court will mandate a mediation between the parties. But the only disadvantage of this type of mediation is when it's court mandated, there might be unwillingness on the parties to reach an agreement. Then we have the Med ARB. In Med ARB, which is a mediation arbitration hybrid, parties first reach an agreement on the terms of the process itself. Unlike most mediation, they typically agree in writing that the outcome of the process will be binding. Now we have features of mediation. Now, just like negotiation, mediation is also flexible. It's voluntary. It involves neutral mediators. It is a confidential process, and it's also negotiation based. Only the mediator would not get him or herself involved in the process. Now, there are different stages of mediation. The first is the pre-mediation stage, which is considered the preparation stage. Then we have the opening stage. In the opening stage, the process officially begins and will involve opening statement. This is when we have this mediation is that process where we have our Steve Harvey, Mike, what's the name of that movie again? The suits kind of thing. So there's the opening statement, and then we now go to the next stage, which explores all aspects that needs to be explored. Then we come to the negotiation stage in the mediation. Then we come, lastly, there's an agreement that is reached. There are some similarities between mediation and negotiation. One, both of them are similar in the way they are used. Both of them are techniques used to resolve disputes between parties in order to come up with an agreement. Secondly, both are also consensual, so it's not supposed to be imposed except the court mandated mediation, of course. The third one is both seek to mutually have acceptable outcome to resolve the problem and handle the situation while also building a strong rapport. Another one is both involve some communication and problem-solving skills. Both can also be used to avoid costly and time-consuming litigation. Both are flexible. Now, there are differences between mediation and negotiation. One of them is the cost. In most instances, negotiation is usually cheaper than mediation, as there is an additional cost in mediation not known in negotiation at all, such as the mediator, the venue, the transportation cost, the agreement draft, amongst others. Another one is speed. So negotiation is usually quicker than mediation in most cases. Another difference is flexibility. Negotiation is seen to be more flexible of all the ADR mechanisms, and it completely at the control of the parties. While on the other hand, mediation might not be as flexible, and it also involves being done in the presence of a third party, even if the person is impartial. In the process of in the course of party autonomy, under mediation process, the parties have greater control over the process, although negotiation is wholly and completely under the control of the parties, while mediation may not be. Settlement and enforcement. Settlement in mediation are arrived at with the assistance of a third party, while negotiation can just be reached by just the disputing parties. Then formality. Negotiations can be more formal or informal, while mediation are usually formal and structured. Confidentiality. Negotiation may be regarded as more confidential since there is no presence of a third party than mediation. And the outcomes. The outcome of a negotiation is an agreement, while the outcome of a mediation is typically a resolution or settlement of dispute. So in conclusion, negotiation and mediation are essential alternative dispute methods that promote amicable conflict resolution. Negotiation allows parties to directly communicate and reach a mutually benefiting solution, while mediation introduces an impartial third party that facilitates discussion. So both methods emphasize cooperation, flexibility, and cost effectiveness compared to the traditional litigation. And by fostering dialogue and preserving relationship, they produce effective avenues for dispute resolution across various sectors. Understanding the advantages understanding the advantages can empower individuals to make decisions about conflict management. Thank you.
All right, thank you very much, Shoma, for helping out with that presentation. Well done to you and your team members for putting the presentation together and on time. Well done to Group 1 in general. I'm sure our mentors were able to hear the presentation that Shoma gave. Sorry, my background is very, very dark. That's the reason why my video is not showing. It's supposed to be on, but my background is really, really dark. I sincerely apologize about that. So before we take or we have our mentors come and give lights to the topic of today, that is an overview of ADR. What we'll be doing right now is taking pictures so that for those who still have some form of lighting in their background, we can quickly take a picture for our posting, and then we can continue with the rest of class. So please, if you have some kind of lighting in your background, I would like to kindly ask that you turn on your videos so that we can take a quick screenshot of the class, and then we can move on to our mentors giving us their presentation and also giving feedback to the presentation that was made by the mentees, and then we'll take questions, and I'm sure we can just have a quick class and call it a day. So please, I would like to kindly ask if you have like some kind of lighting in your background, can you kindly turn on your video? Thank you so much, Mr. Saliu. Thank you so much, Perpetual. Can we have more mentees turn on their videos if that would be possible? All right, can we have more people turn on their videos? Okay, thank you so much, Hawa. All right, thank you so much for cooperating and turning on your videos to take the quick screenshots. So we'll be heading over to our mentors. So for this class, we have Mr. Nyachan Nawan and Miss Natalia as our mentors for today's class. Please, we would like to just hear from them. Firstly, from Mr. Nyachan, just give us, in his own thoughts and his own word, his own take on today's topic. And if he has any feedback he would like to address, and then we'll move on to Ms. Natalia, also give us her own take on today's topic and also feedbacks to the presentation. If there are things she would like to correct from the presentation, if there are other misconceptions, and then we'll take questions. Mr. Nacham, are you with us, sir?
Dennis, sorry.
Yeah.
Dennis.
Yes. So sorry, I can't really hear you.
Group 2?
Yeah, sorry. On Group 2 couldn't
I said, do we have Group 2?
No, sir. We don't currently have Group 2's presentation, sir.
Okay, all right. Natalia, I hope Natalia is here with us. This is just the beginning, the new session that just commenced.
Very much.
And we're looking at, can you hear me? Can you hear me?
Yes, sir, we can hear you, sir.
All right, so I will just make a few comments and then Natalia will expand on it. This is the first day and we're looking at overview of ADR. And I know that Group 1 has done well. They have given us the definition, the overview, the types, the advantages, which is very good. I believe that next week we are going to be looking at in details, especially starting from mediation to arbitration. So the advantages that was mentioned, mostly it saves time, it maintains relationship, which is very, very crucial. So I think let me commend that group for a job well done. More importantly, I'll hand over to my colleague Natalia to give her own input and make her contribution in respect of some of the things that has been discussed. Thank you. Natalia.
Okay, good evening, everyone.
Good evening, ma. We can hear you, ma.
Okay, so you're going to excuse me regarding my video. My network has been acting up lately. So in trying to preserve that, you kindly permit me to have it off. Any other time I can bring it on. Okay, so let me comment. Okay, let me commend Chioma, who presented on behalf of Group 1. Well done to you and your team for your research and your presentation as well. Okay, so a few things I observed on your presentation. I know you didn't want to dwell much because it was an overview, but there's something important that stands, you know, the ADRs apart. Starting with mediation. Of all the ADR mechanisms, it's very unique. It runs through all of them, but more importantly in mediation, and that is confidentiality. So when you were mentioning those things, I didn't see or hear at any point in time where you mentioned confidentiality. And that is the bedrock of mediation and most ADR. If the process is confidential, then the parties can trust the process. You were right when you said that when it comes to negotiation, the parties are directly involved. And then you said in mediation, you don't have that autonomy. That's not entirely correct. Maybe in comparison to negotiation, but when we talk about mediation, one of the things about confidentiality is party autonomy. That's one ADR mechanism that sets it apart from arbitration, conciliation, and some other ones as well, and early neutral evaluation. Now, for mediation, it's important that you bear that is that confidentiality that gives the parties the trust in the process. So if you see an ADR mechanism purportedly referring to mediation, if confidentiality is absent, then you know that it is not mediation per se. So parties take that decision. Now, when it comes to mediation again, the mediator does not decide for the parties. The parties take ownership of the entire process. The mediator is there to facilitate that communication between the parties, and that's to actually guide them back, to guide them throughout the process. And if they are veering off from the agenda of the day, the mediator has that role to bring them back so that they don't lose focus. But while mediator may talk 20%, 80% more or less of the discussion belongs to the parties. So well done in your research. I will ask that your team, read more or rather research more about who a mediator is. When you understand who a mediator is clearly, you have even a deeper understanding of the ADR process. Sometimes they look alike. Can you hear me?
Yes, ma'am, we can hear
Yes,
you.
ma'am, we are with you, ma'am.
Okay. So that's basically. So it's important that you go deeper. And so in having a deeper understanding of the mediation process, you also understand that's important that the mediator, the role of mediator is important for the mediator to actually be studied as well. So once you do that, you're able to have understanding. So that's basically. So if I'm to score you and your team regarding your presentation, I'll give you 70 over 100. We're not here to score. When I say 70 over 100, even in school, lecturers don't give all the marks, right? Can you all hear me?
Yes, ma'am, we can hear you, ma'am.
Hello? Yes. So
Yes, ma'am,
70 is an A. 70 is an A. So I won't give you all the marks. I'll just keep some for myself so that I can share with other people as well. But I'll commend you guys. You guys did a fantastic presentation there. So well done. And I wish you all the best as you journey through the ADR ladder. So I've been told to talk about this, about ADR, an overview. So basically, Choma already mentioned it, what ADR is all about. In the simplest explanation, it's a mechanism for resolving disputes outside of the courtroom without going through litigation and all of that. And the process is structured, but also very flexible. And then parties are allowed to, address their conflicts, have it resolved. And as is very common with all ADR processes, it's cost effective. When we say it's cost effective, it is in comparison with litigation. It spends so much money on litigation, filing processes, court appearances, when matters are adjourned back and forth, when a judge orders that you go and amend your pleadings and all of that. It's cost effective. Energy is wasted, time is wasted. Unlike ADR, it's time, effective, very efficient. You save time. My very first mediation as a mediator, I resolved the matter within 1 hour, 30 minutes. And there's been other cases where I resolved matter in 30 minutes. And, that's knowing how the court system works, it was very like, wow, can this really happen? So I terms those things that we were taught during our time. And so mediation, or ADR in general, is cost effective, it's efficient. Parties, like Choma rightly mentioned, it seeks to mend relationship between the parties. So it's widely used and applies in every field. Commercial transactions, labor disputes. Mr. Nanchang is here. He can tell you because he's an an employment and labor, expert. He can tell you in that regard. It has been used to resolve it. Family matters, divorce. It is the court that grants divorce, quite all right. But when parties come together during mediation, they're able to have a conversation, which they would ordinarily have the opportunity to do that inside the courtroom. They are able to express themselves. But if they were to go to court, it is the lawyers that will speak on their behalf. So all those things that always cause a problem within, between parties, like custody issues, maintenance, visitation, and all of that, they're all resolved within mediation. It saves time. And then the agreement is now taken to the court, to the ADR judge, who will call the parties and ask them, is this what you decided? And once that happens, it's entered as a consent judgment between the parties. International disputes. And the word of ADR is actually right now evolving. So in understanding ADR, it's important that you understand that it has different. So most time when you talk about ADR, most people think it's just about, it's only mediation and negotiation. No, it's a whole lot. There's the early neutral evaluation, there's the conciliation, there's so many of them, right? So in understanding ADR and the importance, it's about the processes used in resolving disputes, like I already said, out of the traditional court system. It's designed to offer parties greater control over the process. That's why I said it's party-driven. And the whole essence is to promote fairness. When parties have the opportunity to speak, they're able to express themselves. The confidentiality is there, the efficiency is there, and the ability to choose the time and then location as well. Besides coming for physical, even online, that can also take place. And now we have AI too. There's so many. The dynamism is so much. So what it does is to help to reduce the congestion of the courtrooms and all the delays that we experience, the series of adjournment, court not sitting, and all of that, and then it helps to, clear the backlog. Since the emergence of ADR, it has actually helped to decongest the court rooms. So I don't want to dwell too much on background, because I know from what Chioma did, she mentioned some things. So it saves costs. We already mentioned that. And then also encourage collaboration between the parties. Parties are able to decide by themselves how they want their decision to be resolved. And it helps to also preserve relationships. So the key methods we're looking at in ADR, the different methods of ADR, which is mediation. I already mentioned that. Mediation. So mediation, it's a voluntary process. It's confidential. There's a neutral third party, the mediator, which is what I told Chairman and her team to read up about, and they will know there's so many roles that mediators perform, and they are not supposed to, interfere or decide for the parties. That's why they are called impartial umpire or neutral third party. They have no, they have nothing to gain from the outcome of that. If they have anything to gain, it means that they have breached the confidentiality, and one of the parties or even both may not even trust them. And once you as a mediator, parties can't trust you, you see, that's the beginning of the process not even succeeding in the first place. So as a mediator, your role is to facilitate communication between the parties who have dispute. You are to help them reach a mutually acceptable agreement. Helping them does not mean you tell them what to do, but you, through your questioning skills. Chioma mentioned skills. So those skills that you get as an ADR, as a mediator, you are able to give them the guidance. As a mediator, you're a guardian. You are a facilitator. You are a director. You are the process manager. You must manage their emotions. You must manage how the parties. So that's why you have ground rules that are set. When parties are trying, you tell them not to insult themselves. You tell them to be civil, to be respectful, and also build trust and rapport. With all of these, parties are able to trust you as a mediator. Once the parties can trust the mediator, you have solved, I dare to say, 50% of the disputes, because they trust. Not that I'm neutral. Parties don't want to hear you say it. They want to see it in action, that you are actually neutral, not by words, but by your action. So the key things to actually look out for in mediation is that the mediator does not impose a decision on the parties, but guides them toward a resolution. Another thing you need to note, which Chioma also mentioned, is that it is highly flexible and can be tailored to suit different disputes. So what works for this particular dispute may not work for the other one. So as the mediator, you must find that way of helping each party based on the different dispute that has been brought. The process of mediation also fostered improved communication and building relationship. Parties come to have their matters resolved, okay? And they look up to the mediator to guide them. So that's why when parties come and they are new to mediation, as the mediator, you have to explain the process to them. And so also, it's not just about mediation resolving disputes. When can you use mediation? You can use mediation to resolve family disputes. Like I mentioned earlier, during divorce, child custody, maintenance issues. You can use mediation to resolve workplace conflicts at the place of work, employment disputes. You can help them resolve the dispute, put them through. When two of the employees are having issues, as the mediator, you find a way to help them resolve it, because if you don't, it will affect the growth of the organization. So it's important, and that we understand this aspect. When there's a business disagreement, commercial dispute, mediation can be used. Okay, we are looking also at arbitration. That's another mechanism, another method of ADR. So arbitration is a more formal ADR process where the neutral party, who is known as the arbitrator, hears evidence and makes a binding decision. Sometimes it may not be binding. So based on the merits of the case, the arbitrator looks at it and is able to pronounce, make, decisions. Unlike the mediator, who cannot make that decision. The decision-making process lies in the hands of the party. But when it comes to arbitration, it is the arbitrator who does that, having listened. So in mediation, we don't call for evidence. But in an arbitration, you can call for evidence. In mediation, you can ask the parties to bring the documents if they are relying on some documents when they are talking, oh, I gave this person this document and all of that. In mediation, you can actually say, okay, bring it. You asking them to bring it as a mediator does not mean that you are calling for evidence. No, you just want to look at it to have a better understanding of that matter, and it also help you as a mediator. But in the case of arbitration, the arbitrator calls for evidence. Oh, you said this. Oh, yeah, bring, let's see it. Let me see. Look at it, and it helps them to come to a decision. They make a decision, and their decision is binding and enforceable, like the judgment of the court. And when it's not binding, it's in adversary nature. It's adversary nature where the outcome, the decision by the arbitrator is one of advice. Maybe they want to clarify something. Now, the arbitrator acts like a judge and makes a final determination, even though he's not a judge. That's why we say it's a less formal process in comparison to litigation, where the judge gives, has a formal setting. But the setting, why it's less formal is because unlike the judge who wears the apparel of a judge, the arbitrator does not wear it. They may decide to, but they make it less formal so that parties can feel more relaxed, unlike in the courtroom. And, the arbitrator offers greater procedural flexibility. So that flexibility that ADR is known for, you can get it in arbitration, but you can't get it in litigation because litigation is very rigid. But arbitration is more flexible when it comes to comparison with, with litigation. And when can we use arbitration? In commercial disputes, construction contracts, international, trade disagreements. Even mediation can be used too when it comes to construction contracts, but it's a very complex, level. So that's why people most times, when it comes to construction matters, they would prefer to go through arbitration because they feel that they will get more when they go through arbitration. Now, there's this, let me quickly add that there's this wrong notion that people bear that mediation decisions are not binding. In fact, I heard someone arguing about it recently. Perhaps the person is not even aware that before the Mediation and Conciliation Arbitration Act came to be, that the outcome of mediation is an agreement in itself, and we know as simple contract, a contract is binding. Why these arguments are going on, the act, the AMA Act, the Arbitration and Mediation Act of 2023, gave it the support, makes it a binding decision. So nobody can claim now that mediation decisions or the outcome are not binding. They are legally enforceable. So you can use arbitration during commercial disputes, during construction contracts, international trade agreements. There you can use it. And we'll come to negotiation. Choma already did a good job with that. So it's an informal ADR process where parties engage in direct discussions to settle their dispute without third-party intervention. People start off with that. And where it fails, it goes. That's why some contract agreements are clearly stated that when there's a dispute, parties will first of all go through negotiation. If it fails, then they resort to mediation. Where mediation fails, they go to arbitration. Where arbitration fails, they go to court. Some will say if mediation fails, go straight to court. So anybody who's drafting the contract has to, include any of the ADR processes. is very important because we are trying to decongest the court. So try as much as possible to ensure that there are ADR clauses in that. It helps parties to be able to resolve their disputes without going through all the rigors. Because the longer the matter is in court, the more damaging the relationships or or business partnership becomes. And so negotiation, parties themselves take that, they try to negotiate between themselves. No third party intervenes. Even when their lawyers are there, they only help them to make sure that they make the right bargain. So the key features of negotiation, I already mentioned, it's parties retain full control over the outcome. It is cost effective and quick. Negotiation skills are essential in all other ADR methods. Yes, as a mediator, you need to be able to negotiate. And you might say, okay, but I'm a third party neutral. How do I do this? If you don't understand negotiation skills, how do you help the parties? Guide them. Because sometimes as a mediator, you encounter a power imbalance where someone doesn't have the power to bargain well. And mediation is all about fairness. So how do you help the other party to have a fair bargaining without you telling them, why don't you ask for this? Your questioning skills and your knowledge of negotiation and negotiation skills will help you as a mediator to be able to guide. Remember, you're a guide. You're not to tell them what to do. If you the party is asking for 3 million, meanwhile, what the party would need that will be fair is 7 million. As a mediator who understands negotiation skills, through your questioning skills, you're able to, direct the party on how to negotiate. You ask questions that will make the party think, to reconsider their position and be sure. And a party who understands those questions will be able to understand that, oh, I need to actually sit back. Let me reflect on this. You have helped that party to negotiate without directly telling them what to do. And that's why it's important that you know how to negotiate as a mediator. You must have that skill because you need it to help the parties without directly telling them what to do. So the beauty of negotiation is that every other ADR method requires that skill. So when do we use negotiation? During business contract discussions, employment disputes. Every disagreement requires negotiation. Everything, every ADR, they all require negotiation. So that's why it's very important. Another aspect of ADR, since we are looking at the overview, is conciliation. Now, conciliation is similar to mediation, but involves a more active role for the conciliator, who will suggest possible solutions while facilitating communication. So if you're confused, like me, when I used to be confused about conciliation and mediation, and I was like, okay, these things are similar. How do I differentiate? The simplest way to be able to differentiate between them is that while the mediator, cannot be actively involved, telling parties what to do, suggesting to them, the conciliator can do that. He can suggest possible solutions to the parties, but without also taking away the power of decision from the parties. So what are the key features of conciliation? The conciliator may offer recommendations, but does not impose a decision. So much as they will be involved, much as they would be actively involved in their role, suggesting, all they are doing is they're suggesting and making recommendations, but they cannot impose a decision. Remember that the power to decide lies in the hands of the parties themselves. So most times where you find this is in industrial disputes or consumer complaints, where you see consumers who go to report to the Consumer Protection Agency, and then they come to court for mediation. So I'll come for conciliation. So they use that to be able to sort it out. And so when is it used? What are those key features? Offering recommendations but not imposing, and then industrial disputes, consumer complaints. When should we use conciliation as an ADR mechanism? You use that during a labor and employment disputes, consumer protection matters, like I already mentioned. Another aspect of, early neutral ADR mechanism is the early neutral evaluation. That one is very key. Very confusing as well. Early. Well, how do you mean early? At what stage? So early neutral evaluation is where an expert, and most times either the person is a retired judge, an experienced lawyer who has been in the field for a long time, they have the expertise. So they're able to actually evaluate the strengths and weaknesses of each party's case and provide an advisory opinion on the likely outcome in court. So they are called early neutral evaluation, because they will look at the, listen to the disputes, they look at the dispute, they look at us, okay, if you go to court, here are your chances. Here are your chances. You will succeed here. You will grow and be able to succeed in your field. And if you, these are your strengths, these are your weaknesses, And so the party look at it. Should I go to court? Should I, because now you are getting experts' opinion. It's an opinion, but an advice to you, because they look at it, look at the strengths of your case, look at the weaknesses. They tell you if you go to court, you are likely to succeed. In some other cases, they tell the party, if you go to court, your chances of winning are very thin. So I would advise that you abandon it. I would rather suggest you go through mediation or go to, for a negotiation. I always be like, this is always even the first step in the first instance. Because when you do that, you save yourself a whole lot. In fact, it's even more cost effective getting an expert opinion before you decide to go ahead. That experience, that opinion will help to guide the party to decide whether or not they will go ahead or they will abandon it and choose other methods. So the key features you have to look at for when we are talking about early neutral evaluation is that it helps the parties to understand the merits of their case. It can encourage settlement by clarifying legal positions. So apart from helping parties to understand the merits or demerits of their case, it can also, because it's an advice being given, they say, okay, if this is it, because this person in question is giving an expert opinion, could be a retired judge, could be an experienced lawyer, somebody who is an expert in that field. They give that expert opinion and they're able to say, okay, you know what, rather than us going to court and wasting money, time, and energy and all of that, this has clarified the position we are seeking. Let's go with this. So they're able to now decide on their own. And when do you use early neutral evaluation? You do this during commercial, disputes, complex ones. There are some commercial disputes that are very complex. There you can use that. And so also with legal malpractice cases, you can look at all of that, So that's about the different mechanisms. So now we'll move to advantages. If you are listening to Chioma, rolled out some advantages of both mediation and negotiation, and also mentioned the aspect of, the advantages of ADR. So I like when I'm talking, I want to stop and ask, is anyone still listening? I want to show
yes, ma'am.
myself.
We are with you, ma.
Yes, ma'am.
Okay, thank you very much. So advantages of ADR, we all know it's there's numerous, so many of them. So it's cost effective, it's very fast. The processes resolved, they are faster when compared to litigation. Of course, we say it's cost effective. Why? Because the legal fees are reduced. The court costs, all those things, they are reduced. So ADR is attractive because
when compared to litigation, it is cheaper for the party. So why spend millions to go to court and prove a point when you can actually go through ADR, save money, save time, save energy, and more importantly, save your relationship. When you go to litigation and the judge gives a judgment, most often than not, one party always carries everything, wins it all. And that leaves a bitter taste, between the parties and cause more rift. Unlike ADR, where we say it's a win-win situation. You let go of some, you win some. That way, everybody has a balance. You can't take it all. I can't take it all. So confidentiality, like I said, it is the bedrock of ADR processes because it is private. In the courtroom, there are other people who are there listening. In the past, members of the public will come to court and sit and hearing people's story. Imagine it was this time of social media. People will video and then throw all the matter in this thing. That has been reduced. People can just go to court and sit down and be listening. Only the lawyers who have matters in court. But even at that, there's no privacy because even though the lawyers are other lawyers who have their matters in court, everybody will be listening to your case and they will make a story of it. Some even record it codedly and share on social media and you're surprising yourself there. But when it comes to ADR, especially in mediation, you sit down there. Only the mediator and the parties and their lawyers, if they decide to come with one. They are the only ones in that room. No other person is allowed in. If you don't have the matter, you can't be in that room because of confidentiality. There's flexibility. We talked about it. Allows the parties to tailor the process to their specific needs, their time and venue, and how they want it. And then more importantly is that immense relationship, preserves relationship, and encourage amicable settlements. And this is more with mediation and conciliation. And so again, it is with party autonomy. Parties have a say in the process. In the courtroom, it is the judge that imposes that to them. But in mediation, in ADR, the parties have greater control over their own matter. The mediator is just there to guide them when they are veering off, the structure of the agenda of this thing. As lovely as ADR is, it still has some disadvantages. So a power imbalance, I mentioned it earlier, when a stronger party try to dominate negotiations and leading to unfair settlements. So when there's a negotiation, don't forget that there's no neutral third party, there's no mediator when it comes to negotiation, it's the parties themselves. So imagine a landlord and a tenant negotiating. One person have an upper hand, even though there are some tenants that are terrorists, they terrorize their landlords, and landlords are afraid of them. Imagine an employer and employee. The employer is the one that pays the salary and takes the tone. So there's a power imbalance. That's one of the challenges. Or a husband and a wife. So there's a power imbalance. Then lack of precedents. Unlike court decisions, ADR resolutions do not create legal precedents. And the reason is because of the confidentiality. You can't be building. So the only way to deal with that is when you attend trainings, webinars, seminars, they talk about it and how to go about it. But you see, the courts can refer to precedents. The fact that we say ADR is an alternative, a better alternative to litigation, there are some things that you cannot use ADR to resolve. For instance, in ADR, particularly with mediation now, you cannot pronounce or make a declaration when it comes to a title to ownership of land. You can't use mediation to, to dissolve a marriage. That can be done by the court. What mediation can do when it comes to matrimonial matters is to deal with the issues of child custody, maintenance, visitation, and everything that needs to be resolved, property distribution, who is going to get what. So it saves the time of the court. Once that is sorted out, every other thing is settled. So those are some of the limitations. And then in ADR, ADR does not always allow extensive evidence gathering, which may be a disadvantage to some parties. And a typical example is in mediation. I said that you can only call for evidence, just look at it to help understand the case better. However, you cannot call for evidence in that regard. In arbitration, you can do that, call for evidence, helps the arbitrator to take a binding decision. But it's limited when it comes to that of mediation. So that's it, basically. So I'll just quickly say that if you want to succeed in the field of ADR, you must develop your skills. And that includes effective communication. You must be able to listen actively and convey ideas clearly. Parties must understand what you're saying. As a mediator, you must be able to communicate the needs of one party to the other party and bring back the feedback to the other party. Manage, so when you don't understand what the parties are saying, that's where clarifications come. You retaliate, you repeat and ask them, are you following? Did I get it correctly? When you summarize, that summary helps you to, parties may say, no, you missed out on this. So you're able to clarify, what you want. And fine, okay, oh, thank you, I'm sorry. It happens. There was a time I missed out on a particular thing the party said. And so when I summarized, party said, yes, but this is not complete. You missed out this one. And when it comes to dealing with figures, you can make mistakes. Parties can help you clarify. That's the beauty. So if you're not listening, you would miss that. And because that listening skill is very important. If you listen so they can understand and be able to help the parties. And then in negotiation, like Choma said, you must, know how to negotiate, help parties craft that solution that will satisfy all of them. When during the bargaining phase, they are bargaining, trying to negotiate, either you're using negotiation or you're using bargaining. When they are bargaining, they're negotiating. They're trying to say, okay, I propose this. That one said, I want this. Begin to talk. As a mediator, your skills must be up. Help them, guide them, so that they make better this and that will favor everyone. And then emotional intelligence. You must be emotionally intelligent to manage your emotions. You understand yourself as a mediator, manage your own emotions, and also be able to manage the emotions of the parties. Some mediation rules are very toxic. So as the manager of the process, you must be emotionally intelligent, knowing when to, stop the parties. And that's why it's important at the beginning as a mediator, you set the ground rules. Even during negotiations, even in arbitration, you set the ground rules. Don't insult, be polite, and take turns, wait for your turn. Set this in. If parties are going against it, you bring them back to say, no, remember we had an agreement. And that's where it's important that parties will sign the agreement to mediate. And also the confidentiality. That's where they are, bound by their agreement. You remind them of it. And then impartiality. As a mediator, you must maintain neutrality. When Chuma was talking, he said you are like an impartial umpire. You have no stake in that outcome. You're supposed to be, Mr. A must see that you are not for the other party. Mr. B must see that you're not for Mr. A. You must balance the outcome. Otherwise, you lose one party, and once you lose it, you can't proceed anymore. And then there's the problem-solving skills. You must generate creative solutions as a mediator. You want to succeed in this field, help the parties understand that, as they're generating options, you must, use your questioning skills to do reality testing for them so that they understand that the solutions they are proffering, is it reality or is it unrealistic? So that's, and then knowledge. You must understand relevant laws and regulations. It's for lawyers, it's so easy. For non-lawyers, it can be a bit challenging because they're not trained in the field of law. However, there are some people, and that's why they have to seek expert opinions for non-lawyers, or they research on it, ask questions from their legal counterparts, have a better understanding, so that at every point in time, as a mediator, you must be well equipped. And then you are students now, desiring to prosper. And then for some of you already who are not students, later in the future, if you want to build a career in that line, the line of ADR, then you must continuously gain relevant knowledge. That you're studying law, you're studying conflict resolution, or any related field. Gain knowledge, specific knowledge in that area. Obtain certifications. I said I was going to find Dennis, who did not read out my profile. I'll find him later, not now. So if you listen to when he was reading out Mr. Nanchang's profile, you will see that he mentioned some things. Mr. Nanchang has obtained not just local certifications, but international certifications from recognized ADR institutions. You know why? It helps to enhance credibility. When you hear USA, when you hear India, when you hear this, when you hear that, it helps to give credibility because these are recognized ADR institutions all over the world. Even within Nigeria as well, there are recognized ADR. Most of those state multi-dot courthouses, they are recognized institutions. So you have to obtain certification in them because in this part of the world, whether we like it or not, certification is something that we are being asked for. If you don't have it, it is that you don't have the requisite knowledge. And then also, besides having these certifications, it's also important that if you're going to be building a career in an ADR, you have to develop practical experience. Go for internships, go for mediation observations, go for ADR simulations, moot court trials, even when peer listening, even other adults are having workshops. For instance, Nanchang is also he and I we sit to as expert assessors, assessing international students when they come for moot trials or come for competitions. We're able to look at them, observe them, give our recommendations, tell them where they are supposed to improve, tell them where they are supposed we commend them where they did well, and then tell them the areas they're supposed to. So if you want to gain experience and pursue a career in ADR, these are the things you have to do. Join ADR organizations. There are so many of them. There's the American Bar Association, which I belong to. There's Institute of Arbitrators, Chartered Arbitrators. Mr. Nanchang is part of them. There's the IMI that Mr. Nanchang belongs to. There are the multi-door courthouses. It's actually important that you join them. And then also continuous legal education. When you continue to learn, you improve because right now there are so many dynamism to ADR. Things are changing. AI is here now. We're having so many things. I'm even as a mediator who has been practicing for years, I'm also running to make sure I keep up to. There's so many. Before you think you know this, another one comes up again. Before you think you know this, another one comes up again. So constant learning, interaction with your peers, it helps. Goes a long way. So finally, I'll just say that ADR it's a crucial aspect of modern, resolution. So offering practical and effective alternatives to litigation. So if you are aspiring, then you have to prepare yourself, and then also be involved. Volunteering to can go a long way in helping you find your niche. So that's basically invest in education, gain hands-on experience, ask questions, look for mentors, and then develop strong communication and problem-solving skills. If you have these abilities, you'll go a long way. Thank you very much. I'm done. If you have any questions, Mr. Nachang and I, we are here to answer. Thank you.
Thank you so much, Ms. Natalia. We really, really do appreciate that very, very insightful session from you. I'm sure alongside the next, we were able to learn. We were able to learn a lot. Mr. Nyasham, do you still have any contributions you would like to add before we take questions? Sir? Mr. Nyasham, are you with us, sir? Okay. Okay, since Mr. Nyasham is not currently here with us, but what we'll be doing right now is, since we have Ms. Natalia here on call, right, we'll be doing very well. I'm sure she will be really, really, really excited to have us ask questions, which she will be really happy to give answers to. So please, do we have any mentee who has any questions they would like to ask Ms. Natalia and Ms. Nyacham? I'm sure they will do well to answer your questions. So please, if you have a question, please kindly raise your hand or indicate. I'll do well to read your question. I'll do well to call you out to take your question. You can also send your question into the chat box. We'll do well to read it out and send it or ask it directly to the mentors for a response. Do we have questions, please? Do you have questions for our mentors? Okay, while we're waiting to take questions, I think I would first like to ask a question before we take other questions. So my own question is, apart from, are there particular cases that cannot necessarily be handled through alternative dispute resolutions? Like, are there particular questions that you actually need litigation, or litigation is the only form or the only option from which we can settle particular issues outside of ADR?
Yes, there are. Hello, can you hear me?
Hello, ma. Yes, ma. I can hear.
Yes. So yes, in most criminal matters, in the case of rape, for instance, you cannot use mediation to do that, because how do you want to? So it will come from under. How do you begin to question where there's a crime that's been committed, a crime of rape? How do you want to bring that before the mediation? I guess that was one of the reasons why they brought up this. Yeah, somebody already dropped something in the system and on the chat. I mentioned that dissolution of marriage, declaration of title to land, and somebody added winding up of a company. These are the things that you cannot but go to court for. And I said, when it comes to dissolution of marriage, what you can have is parties trying to resolve issues surrounding custody issues, because that will be asked in court. And that usually takes time, especially in very toxic divorce proceeding, contentious divorce proceedings. So they coming for mediation, family mediation, is not for the mediator to dissolve marriages. It is the court that license the parties, and that it's the court that would dissolve that marriage. When people are fighting for land, you can't do that in mediation. I'll say, oh, Mr. A, nobody will be willing to give out their land just like that. The court will determine through the evidences, facts presented before it, to determine the true ownership. That cannot be done for mediation. That what mediation can do is just help parties resolve, broken relationships, but it cannot give that as well. In crime, I mentioned crime as well. In a murder case, that cannot be done. It's a state that handles it. I have a present criminal matter. It's for mediation. Now, the aspect of that mediation has to do with theft. So the other party is willing to so they're trying to say, okay, and that can be used. And recently there's this restorative justice as well. That part too also helps, where the criminal, we say we shouldn't call them criminal, the offender comes face to face with the victim. You know, that's another aspect of it. But when it comes to resolving this thing, like Perpetua already, put in the chat, you can't use mediation to determine this. I hope that's clear.
Yes, ma'am, that's very clear. Thank you very much, ma'am, for expanding on that. All right, so we have another question on the chat box. It says, during the overview, you said one distinctive feature of mediation is confidentiality. Is confidentiality not also obtainable in arbitration? That's from Imelda.
Imelda, thank you very much. So yes, I mentioned that, but if you also listen, I mentioned that when comparing ADR with litigation, I said that one thing that sets ADR apart from litigation is that, one thing that runs through all the what's it called, ADR processes is that confidentiality. But you find that confidentiality is the bedrock of mediation. It's a very distinctive feature for mediation, that it can have every other thing, but if you don't find confidentiality in that place, you see, because people can have the documents, they can publish it, they can keep it, take it anywhere. But in mediation, the parties sign those processes, just like they also sign in arbitration. But it's very unique. That's one thing. For arbitration, the arbitrator gives a binding decision, right? But in mediation, the mediator does not impose any decision on the parties. The parties themselves take it. So that process, in a case where you meet with the parties in private, you cannot take what they have said to you and tell the other party without authorization or the party telling you to go ahead. That confidentiality that plays out also in the private sessions you have with the parties. In arbitration, everybody's seated there. Everything is laid bare. You can't say, let's speak in private. You may want to consult in private and discuss some things and negotiate some, but in mediation, you go into a private session and you begin to discuss. And when you discuss with the party, as a mediator, you cannot come out there and tell the other party, this is what, this is what this person said. You must get a clear permission. That's why you ask the party, should I inform this person about what you said? Or would you rather I keep this and say nothing for now? Clearance. But in the arbitration room, we are seated there with the party, everybody discussing, looking at evidence together and all of that. But that doesn't mean it's confidential, because only those who are there have the right to know it. Any other person does not. But with mediation, besides the joint session, there's a private session where you have with the parties, and you keep that confidential. That's why I said it's a very unique feature, distinctive to mediation. I don't know if I explained that, if that's okay.
All right, that's fine, ma. We heard you. But at some point, your network...
I need the... Oh, okay. My network was bad.
Yes, it was breaking a bit, or I'm not very sure if it was just from my end, or maybe it was everyone who was having that issue.
Okay, maybe we should ask Imelda. Okay, she's left. She back again. I don't know. Maybe she heard me. Ask her if she understood my distinction.
Yes, Amelda, please, did you hear Miss Natalia's description or answer to the question you asked?
Yes, I heard that very well, and I understood this perfectly.
Oh,
All right.
okay.
Yeah.
All right. Thank you very, very much. So thank you so much, Amelda, for that question, and thank you to also Miss Natalia for helping us answer that question. Do we still have more questions from our mentees? Do we have any other person who would like to ask a question? Do we have any other person who would like to ask a question? Okay, while we wait for other questions, I still have a question, and my question is basically, apart from third party or apart from neutrality as one of the core criteria to serve as a mediator, what are some of the other necessary requirements, right, for which someone will need to have for him to play the role of a mediator? I think in one of the last quarter, I think in one of the quarters, the previous quarters, we spoke about how that the role of a mediator can be literally carried out by almost any person. Are there particular requirements that a person needs to have for him to play the role of a mediator?
If I understand your question, you're asking if there's anything unique, something that's a mediator should a requirement to becoming a mediator, right?
Yes, ma'am.
Okay. Yeah, so basically, if you're gonna be, anybody can be a mediator. It's not limited to lawyers alone, right? We have non-lawyers who are also mediators. That's the beauty of this particular ADR, you know. So you have to get trained. Once you go through that formal training and you are successful, and after the successful training, you are inducted into the panel of neutrals, then you can start mediating. So in the field of mediation, you can now decide what area you want to specialize on. Someone to focus on family mediation, someone to focus on employment mediation, someone to focus on construction, being specific in particular disciplines. Some may just have two, some may want to go into the maritime. You look at what you like and say, this is the area I want to go into as a subject matter expert in that area. You develop your niche in that area. So the only thing you need to become a mediator is to be trained. And then as you mediate, you develop your skills and your own style. So that's it. Formal training, that's all that you need.
All right, Smart. Thank you so much, Mark, for helping us answer that question. Do we still have more questions, or can we call it a night? Mr. Nyacham, are you back with us, sir? Mr. Nyacham, are you with us, sir? Okay. All right. So if there are no more questions, I would want to say a big thank you to Ms. Natalia and Mr. Nyacham for joining us for this very, very, very insightful session on the overview of ADR. It's our very, very first class for this quarter. And we still have, I think, about 4 more classes where we'll be treating different areas and aspects of ADR. I want to encourage us to give or take out time to be present for class, to participate fully in all the tasks so that we can keep up with the pace of the program. And when we come to class, we have full understanding of what is happening or going on in class. I'm sure our mentors are willing and prepared to help us break down this very.
Hello.
Yeah, yes, sir. You're with us, sir. Okay, we couldn't hear you for a while, sir.
Can you hear me?
Yes, sir. Yeah, I can hear you now,
Hello.
sir. Yes, sir, I can hear you, sir.
Hello. Hello, Mr. Dennis.
Yes, sir, I can hear you, sir. Your network seems to be a little bit bad.
Okay.
Well,
I
I can
was
hear you
trying
now.
to, I didn't know whether you were hearing me or not.
Oh, okay. I wasn't hearing you, sir. But sir, please, you can go ahead, sir. Do you have anything you would like to contribute to the topic for today?
Okay, well, I will want to say that uh, uh, my colleague Natalia has done justice to some of the things that needs to be said. In fact, I had to ask her to take some time and go more detail because in as much as the research by group one was good and okay, there are certain things that they missed out, which she has pointed out. So remember that this particular class is an overview. An overview, we are not particular about any subject, so to say. We just went picking, just to have an idea holistically. We are going to, in the subsequent week, be looking at particular details. We'll pick mediation, for example, and look at details. So if you have further questions, you can drop them with Dennis. He'll forward it to us. It can be part and parcel of the discussion we are going to be having in the next one. And then please prepare and have questions so that beyond the research you make, if you have these things that you do not understand, it is an opportunity to actually ask them. Because if you are going to be booking a consultation, for example, with an expert, you are going to spend a lot of money. So, but then this mentorship is an opportunity for you to research, do your presentation. We are going to make contributions, but more importantly, have questions that you want to ask in any aspect of ADR, and will be available to give you such answers, in the course of the mentorship. So that's what I just want to draw mentees' attention, and then let's prepare and then send our slides, and then they'll share it with the mentors so that we also keep track of it, and then know where we need to make input. And more importantly, do that. And then aside from that, I want the mentees to prepare their mind. Don't just do mentorship and stop. You can take a step further, get certified. And Natalia and I were both trainers, and we train people to become mediators. And then those who want to become arbitrators, in the course of all those things, we are fully available. So please prepare your mind. In the course of the training, you may see a particular area that interests you, that you may want to develop more expertise on. Please take note of it so that it will not be after, when you finish the mentorship, after 1 week, 2 weeks, you may tend to forget some things. And more importantly, please be jotting down important points. Some of the things that you may be researching, it may just be answered in just few seconds. So please take note of those things, and I know that will go a long way to help us. Thank you very much, Dennis.
Thank you so much, sir, for pointing that
Thank
out.
you.
Okay, thank you so much, sir, for pointing that out. Please, I also want to encourage mentees. Please, let's put in the effort to make sure that we have a very, very wonderful experience over the course of the next 7 weeks and 5 weeks, especially for the ADR class. Thank you to our mentors, Mrs. Natalia,
And
for
also,
helping
please,
us.
Dennis, sorry. Also, we encourage the mentees to share screenshots of what they have, maybe the meeting on their social media platforms. Encourage them to tag JIIPCC, encourage them to tag Settlement House ADR Training Institute that collaborated to bring this training. And then what you are learning here, share it with your friends in form of messages you share on your platform. Let them know that you have started a journey to learn something about ADR, and if possible to specialize. Eventually, they may turn out to be your clients. They may reach out to you when they know that, okay, I've seen somebody made mention of so thing, that he was doing a training of this nature. Can I reach out to him? So that is what I think we should do. Please ensure that you post your WhatsApp status, your LinkedIn, your Facebook, these two organizations.
All right, sir. Thank you so much. Please, I hope we are taking note of everything Mr. Nyasham said. Please try and tag when you after the class. Please post online what you learned. Tag JIIPCC and also tag Settlement House. This mentorship is brought to you in collaboration between. It's brought to you as a collaboration between JIIPCC and Settlement House ADR Institute. So I truly hope that we can spread the word. Right, what you are learning. This is just the first class, right? And we're taking an overview. Subsequently, in the for future classes, we'll be taking or we'll be diving real in depth into the subject matters, the different subject matters and segments of ADR. And I'm sure that you will learn a lot. You will learn a lot from us and from the Settlement House ADR. So please do well to share everything that you are learning so that other people can get to know what is going on here. Please make sure to fill in the attendance if you were present for class today. All right. We'll be sending out a new task for the week before the end of today. All right. So please do well to pay attention to the tasks. I will do well to follow up as much as possible so that we can get to keep up with our tasks and do it when the time is appropriate so that our mentors can receive it and also so that our mentors can receive it and also get to review what you have done. Okay, so can someone hear me?
Yes.
Yes, I can hear you.
Please, can anyone hear me? Sorry, my network had a little glitch. So like I was saying that please let's make sure to do that. When you are posting for today's class, please tag our mentors, tag Mr. Nacham, and also tag Miss Natalia, right? Do well to follow them, connect with them, and I'm sure that they would help you as much as they can. We've come to the end of today's class. I look forward to seeing us in other sessions, fully prepared for class, ready to ask questions, and ready to learn from the very, very, very best. Good night, everyone, and do enjoy the rest of your evening.
Thank you, everyone. Thank you for